Sorry, I had my mic off. This question is, I think, more for Brad. And he had said something in there about you were going to draw these maps under federal law first, if possible, and then state. So I'm not 100% clear about that. I would imagine the public probably is not either. Could you kind of talk a little bit about that, elaborate on that a little bit?
Right. For minority majority district, there's two different standards. So the stricter and kind of better legally defined standard is the federal VRA standard, which basically says if you can draw a reasonably compact district of a single minority and the percentage of that district is 50% plus one person, you are obligated to do it under federal law. Then the next and so when we were doing the VRA analysis for Pleasant Hill, we just very quickly looked, can you draw a minority majority district? And you cannot by federal standards. So then we looked at, okay, what can you draw? And it's clear, as some of the callers said, you can create coalition districts, and you can certainly create districts that are over 35% minority in other places. So this gets us to California VRA law, which Jim can comment, but is not well settled legally. So there's different standards of what could be construed to be a minority district. So I just mentioned a coalition district. So it might be the Asian American community plus the Latino community plus the African American community, all combined to get you over 50%. And so that's kind of known as a coalition district. It doesn't meet the standards of federal law. It probably meets the standards of California law, but it's a little unclear. And then there's another type of district where, say there's a single minority, say in this example, Latino. So let's say we have a Latinx community where you can draw a district that gets to 40%. And racial block voting shows that this group votes, 80% backs the same candidate. So that 40% of the district probably gives them enough such that when they vote with their allied groups, they can control the election and choose their candidate of choice. Again, under California law, this probably constitutes a minority district, but it's not legally settled. Jim, if you want to chime in.
Certainly. Thank you, Brad. As Mr. Wenke had mentioned, under the Federal Voting Rights Act, FVRA, if you cannot demographically demonstrate, say that 10 times fast, if you can't demographically demonstrate that you can create a majority minority district, which, as Mr. Wenke said, a single minority class that is 50% plus one in a district, if you cannot demonstrate that to a court, you don't have a FVRA case. Case is dismissed. That is one of the elements you have to show to sue under the FVRA to make an agency go from at-large to by district. On the other hand, the CVRA, California Voting Rights Act, was deliberately drafted to have a much more liberal standard, a more plaintiff-friendly standard, if you want to call that, than the FVRA. And the necessity of showing that you can draw a majority minority district is not a requirement of CVRA. It's a good thing under CVRA, but if you can show even something less than 50% plus one, there may still be a CVRA lawsuit case that would be successful. Exactly where that line is, as Mr. Wenke said, is unsettled right now. That issue in particular is up at the California Supreme Court right now in the Pico neighborhood versus Santa Monica case. Honestly, we were hoping for a decision last year. The Supreme Court is being very cautious. and asked for a second round of briefing from legal counsel, amicus briefs, which are briefs from organizations like the League of California Cities, CSAC, other public agency groups. And so the Supreme Court will probably give us a ruling sometime later this year, but we don't know when. Nobody rushes the Supreme Court. But where that line is to prove a SIVRA case is unsettled right now. So if you can draw a coalition district that's maybe 30% Latino, another 10% Asian, and maybe another 5-10% African American, that may be enough to be required under the SIVRA. But again, that's not entirely settled law right now. We're still waiting for the Supreme Court's guidance.